Good afternoon, everyone, and welcome to the Legal Hour for January of 2026. Um, as I kind of discussed earlier today, I picked this topic before the situation happened yesterday in Minneapolis, obviously, with the thought on my mind about what had previously happened in Minneapolis and some of our history, but also the fact that I was teaching on Article 1 and Article 2 of the US Constitution this week in my constitutional law class. And so, one of the things that we were talking about this week in constitutional law was privileges and immunities. And so, that discussion led me and my students into a very deep discussion in regards to um, what does this look like for a police officer? And so we're going to be discussing that today. We're going to be discussing that in both the criminal context and the civil context. And we're going to talk about some case law. And I just want to give you all the background information. These are the things that the different branches of government should be looking at as we go forward with what's currently going on, but also as we look at what this looks like in a historical perspective as well. Those of you who know me know that not only am I an attorney, but I have a master's degree in history. I'm a professor. So I'd like to look at it from the multiple different lenses that we are looking at as we go forward and try to figure out what's the best way to address these issues as they come up in our world. Because, of course, we are dealing with some of the different things that we know and see in our world that are on social media that everybody's talking about. But this is something that I see every day. So, there was just another report brought out in regards to resisting and obstructing, which is a state level law in Michigan. And that the county where I live, where I grew up, where my law office is, Berrien County, continues to have the highest numbers of people being charged with resisting and obstructing police officers. It's something that we see all the time. There are cases going on all the time in regards to civil lawsuits against police officers, criminal charges against police officers. And I want to say that it's a very hard job. I'll never forget that I sat on a panel at the university where I teach. And I sat on a panel with police officers, former and current police officers. And one of the things that was the most eye opening to me when I sat on that panel was one of the panelists talked about what they call adrenaline dumps. And there was, as he was describing it, I was like, oh, that's what happens to me every time that I get a verdict in a trial. And I don't do as many trials nowadays, but when I was first starting out my career, all I did was trials. I did trials all the time. Sometimes when I was doing misdemeanor indigent defense, I would do 3, 4, or 5 trials in a week. And that feeling when you stand up and you're waiting for the verdict to come in, it just feels like everything is just dropping out of your body. That's that adrenaline dump that happens before a verdict, for me, before a verdict is read. And that police officer was talking about the fact that most people in their lives, their entire life, maybe have a couple of adrenaline dumps. So I, as a criminal attorney, have had more than that because, like I said, the only time I've ever had that situation is when I'm waiting for a jury verdict. And it's happened every single time. I've stopped counting jury trials a long time ago. I've done over 100 of them. It happens every single time I get a verdict. No matter how confident I am in the verdict or what I think is going to happen, I get that adrenaline dump every single time. My body does not stop it. So I've had more than a couple. So the average person only has a couple. And, some people have more. Police officers, some of them have it multiple times on a shift. So something that some people only have, once or twice in their lifetime, some people a bit more. Some people may have every time they go to work. I don't want to discount that. I understand that. I respect that. And so this is not meant to bash police officers, bash law enforcement in any way. But these situations are happening. They have happened. I believe that they will continue to happen because even if they don't make it on the national news, like I said, the charge of resisting and obstructing a police officer in Michigan is charged every single day, multiple times a day, thousands of times a day throughout our 82 counties. So the interactions that people, civilians, are having with law enforcement is happening all the time. And so while we are seeing these things happen on a national stage right now, and there's a big spotlight and focus on them, this information that I'm giving is because continues to happen every day and happens multiple times a day. So we need to know what the courts see as the reasonable officer standard and how that plays out in the courts. I also did talk about last month in December my top 5. And my top 5 for criminal law was video and AI and how that's going to affect evidence. There's a lot of that discussion happening right now. People are seeing videos. People are asking to see more videos that we're not seeing in certain cases. Government agencies are producing videos that have been altered and pictures that have been altered. And this is something that is new that's going to really impact the law, because now we're really going to have to know, like, what are we actually seeing? What are we putting together? Is this, I was watching coverage yesterday, and several of the places were saying we have to authenticate this video before we can show it to you. I had seen it on social media 5 hours beforehand, but they were saying we have to authenticate this video before we're even able to show it to you. Imagine what that's now going to look like as we go through the process of court, whether that be criminal, civil, whatever the case may be. And experts or attorneys are putting these things together and they're saying, is this the actual true authenticated copy of this video that I'm using? Because we don't want a verdict to be impacted by introducing a photo that was not authentic, that was not authenticated. So even when I talk about my top 5, not only does this issue come up in that, but again, it's something that we see every day. People are charged with resisting and obstructing officers every day. There are complaints against officers for excessive force every day. So these are not things that are just pertinent to the current conversation, but something that we're seeing in the United States all the time. If you have questions, comments, you can put them into the chat, whether you're watching on Facebook live through my law office page or through the law office page on YouTube. And for those who are not watching live and you still have questions after it's posted, you can put questions and I will try to make sure that I'm monitoring it and answering questions as we go forward. But remember, this is not legal advice. This is education for education purposes. And I really want to do some education today. You all may feel like students in my law office, I mean, in my classroom, or my interns in my law office for a while, but I think that's okay because I think that that's what is needed for today. So we're going to get into the lesson. The case that teaches us about the reasonable officer standard is the case Graham versus Connor, which is a 1989 case out of the state of North Carolina that made it up to the United States Supreme Court. The United States Supreme Court issued a unanimous decision. People who watch the courts nowadays or have been consistent watchers of the United States Supreme Court recognize that having a unanimous decision does not happen very often. There, you have to be really strong and on a issue of law in order for us to get a unanimous decision from the Supreme Court, be that our current Supreme Court or the prior Supreme Courts. But this was what we call the Rehnquist Court. We base it off of who the Chief Justice was. So Chief Justice Rehnquist was the Chief Justice at that time. I include a little graphic. OAS is one of my favorite websites. It's one that I have my students go to. That's oyez.org, even though if you also put .com, it'll take you back to the same thing. And so one of the things that I love, if you're looking to understand cases better, if you're trying to look at different cases from the United States Supreme Court, is they give you a lot of visuals and pictures. So here they give you a picture of the majority opinion written by Rehnquist and all the judges who were a part of the decision, which includes, some of who we consider to be some of our most conservative judges like Scalia to more liberal judges like Justice Marshall. All of them were in agreement on this case. States' rights versus federal rights, that was big for Justice O'Connor. They all came to the same decision in this case. And I just want to do a little primer for those who either don't know, forgot, whatever the case may be. We're not teaching civics like we used to. We have three branches of government. The job of the Congress is to make law. The job of the executive branch, which is the President of the United States, is to enforce law. And the job of the court is to interpret law. So let's just keep that in mind as we go forward, because I think it's important for us to keep that in mind. So Graham versus Connor from 1989, North Carolina case. The gentleman that you see pictured here is Dethrone Graham. And Mr. Graham was in North Carolina. He was at his home, and he went into some type of diabetic issue. From what it's described, as somebody myself who is a type 2 diabetic, it sounds like his blood sugar went too low. And so he called a friend, and he asked his friend to take him to the store. And in asking him his friend to take him to the store, he was going to go get some like orange juice or something of that nature, in order to try to fix his blood sugar at the time. So they went to a convenience store. And anybody who either is diabetic or knows somebody who's diabetic, when your blood sugar either gets too high or too low, you start acting kind of weird. It happens to me. I can tell when my blood sugar, something is going on with it. I don't always know if it's too high or too low, but things start seeming strange. So when he gets to the store, he runs in very quickly to try to get this orange juice. When he goes to check out, he's at like a convenience store gas station. There's like 2 or 3 other people in line. And so he's like looking back and forth. He's like, I don't have time to wait in this line to be able to buy this. Now some people may say he could have just cracked open the orange juice and started drinking it if that was the issue. But, again, those who know, you might not always be thinking the most clearly when you're in the middle of a diabetic episode. So he runs back out of the store and says, let's go to a different store, because he doesn't want to wait in line in order to purchase the orange juice. So a Charlotte police officer, this is in Charlotte, North Carolina, sees him run in the store, run out of the store. I don't know what else he sees. Does he see him pick up the orange juice? He sees all of this take place. And so he pulls the car over. The officer pulls the car over. And when he pulls the car over, Mr. Graham gets out of the car and starts circling the car. The friend who had brought him, as well as the police officer, are trying to calm him down. And the facts say that at least one way or the other, the friend is trying to tell the officer that he's in the middle of some type of diabetic episode. Multiple other officers show up, and they're trying to get him calmed down. He's, taken into custody. He's detained. There's a struggle. He's fighting them. All of that is happening on the side of the road. They take him into custody. They continue to investigate a little bit further. They're trying to figure out if he stole something from the store, like what is going on, what is happening here. But eventually they find that he hadn't committed any crime. And so they took him home. He doesn't get charged with any crime. He doesn't get taken to jail. He is detained, but he is not charged with any crime. So, but he is significantly injured. His foot is injured. He has a lot of different things that happened to him. Multiple officers had been on the scene in order to detain him. And so he files what is called a federal 1983 civil rights claim. It's always easy for me to remember the 1983 civil rights claim because that's the year I was born, but it may be a little bit more difficult for you all to remember it. I do have that on the side here on my slide. So it was passed in 1996. I don't know, I'm getting older, but that seems like it's not that long ago. But Section 1983 is a really, really heavily litigated part of the law nowadays. So you see many, many civil claims under Section 1983, federal law for civil rights. Important to understand federal versus state. And one of the things I discuss with my students today is that the federal law has supremacy. So supremacy means that when there may be any type of potential issue between state law and federal law controls. So 1983 is a federal, it's 42, Section 1983. That talks about the fact that government employees can be sued civilly, as well as the departments themselves and different things of that nature can be sued civilly if there are claims that somebody's civil rights were violated. And so that is Section 1983. So in this case, the most recent is 1986, but obviously this happened earlier. In 1989 is when the United States Supreme Court heard this case. I think everything happened in like 86, I want to say 1986. But under this, the current, whatever the form of 1983 was at that time, is what Mr. Graham sued under. He sued Connor, who is the officer, the main officer, the one who saw him at the convenience store in the beginning. He sued the other officers that were involved in him being detained, and he sued the City of Charlotte Police Department. And he alleged excessive force, excessive use of force, unlawful assault, unlawful restraint, or false imprisonment, which means false imprisonment means that you're not able to leave, so being detained. And again, I say again, I talked about this in class because one of my students was talking about the young boy who was taken into ICE custody, and they said, well, he wasn't in handcuffs. He just walked to the car. And I said, yeah, but he was still detained, because the question about being detained is not whether or not you're handcuffed, but are you free to leave? That's the main question. If you're not free to leave, whether or not you ask if you're free to leave, whether or not they have given you Miranda rights and start questioning you, the only question that is important for purposes of whether or not you're detained is, are you free to leave? And so even though they eventually found out that he hadn't committed any crime, they let him go. During the time that they were trying to subdue him, he was detained. He was not free to leave at that time. And they also, one of the other things that I want people to remember about this case is that Graham's attorney sued for improperly trained officers in violation of the Rehabilitation Act of 1973. So in all those different complaints, the different charges or counts on a civil complaint: excessive force, unlawful arrest, false imprisonment, and improperly trained officers. So in the lower courts, the lower court decided to grant what's called a directed verdict, which means we've heard some of the evidence here in this case. We have precedent, we have law that we're using. And in using that law that we already have, we don't think that Mr. Graham has any claims going forward. So we're doing a directed verdict. And particularly in reading, if you read through the case, this is really in that use of excessive force. The idea of the police officers using excessive force in this case, the lower court said, we're going to grant a directed verdict because we don't believe that you can go forward with this claim. And so Mr. Graham takes his case all the way up to the United States Supreme Court, and the Supreme Court issues a unanimous decision, which is in favor of Mr. Graham. So we're going to talk a little bit about what the questions were in that case. So again, this is from OYEZ. Again, I love that website, oyez.org, that talks about Supreme Court decisions. So there's two questions that the court is answering in the Graham case, Graham versus Connor. Must Graham, the gentleman who was detained, show that the police acted maliciously and sadistically for the very purpose of causing harm to establish his claim that Charlotte police used excessive force? Question number two, must Graham's claim that law enforcement officials use excessive force be examined under the Fourth Amendment objective reasonableness standard? So those are really the two questions. My legal writing students this semester are forming their own questions, one research question that they're going to pick about a topic. So these are the two questions that were really dealt with in the briefs that the attorneys submitted and what they argued to the United States Supreme Court. So that first question, maliciously and sadistically, you're like, what does that mean? That's kind of weird. Where does that come from? It comes from a case. The case is Johnson versus Glick, G-L-I-C-K. That is called precedent. So with precedent, the court has to go and look at, say, okay, these are our decisions that the United States Supreme Court or other federal courts have already made, or even state courts at certain times. They're looking at state law. These are our cases that already exist that we're supposed to use. So at the time, the rule was that if an officer was going to be criminally or civilly responsible for hurting somebody who they were encountering or detaining or having interaction with in one way or another, The test was that the officer had to be malicious and sadistic, and that their actions that harmed the person who they were interacting with had to have been done for the purpose of causing harm. And that was needed in order to be able to show excessive force. And so the way that the court, the United States Supreme Court in this case, the Rehnquist court, they determined no, it shouldn't have to be that severe. I mean, for somebody to be malicious and sadistic, that is significant criminal intent. Like, that officer had to be going in ready to hurt somebody. I want to hurt this person today. And it's clear from all the evidence that they heard in the Graham case, that's not what the officer was doing in that case. Mr. Graham was in the middle of a diabetic episode. He was trying to get him to calm down. He was also trying to investigate whether or not he had committed any type of crime, whether or not he was intoxicated, any of those things. He wasn't trying to maliciously hurt this man. So if that's the precedent that you're using, then yes, the directed verdict would have been appropriate. But the United States Supreme Court here is saying, no, that should not be the standard. We're going to take that out. So we're going to look at the Fourth Amendment, and we're going to look at the Eighth Amendment. And the reason we're going to look at that is because already there was a bunch of case law that talked about the fact that there is an objective reasonableness standard when you're looking at things under the Fourth Amendment. So the Fourth Amendment talks about search and seizure. And so search is if I go and I want to start looking through your backpack or your stuff. Seizure is when you actually arrest a person. When you detain them, detainment can lead to arrest. And so the court here looked and said, in this case, he was detained. Multiple officers detained him. And so if that's the standard, then what we need to start looking at for law enforcement when the Fourth Amendment has clearly been invoked in this case because there is a seizure. And we also are going to look at the Eighth Amendment, which is part of it, at least talks about cruel and unusual punishment. So what they're alleging is that the injuries that he suffered were cruel and unusual because they went beyond what a reasonable officer should do in the sense of being able to figure out whether or not this man is drunk or high or whatever the case may be, stole something or was going through a diabetic episode. So they said that the standard should be a reasonableness standard. And reasonable person standards, reasonable doctor standards, reasonable lawyer standards, they existed in all different areas of the law. And so this case really said, we need to look at this in a reasonable officer standard. What would a reasonable officer do, or should a reasonable officer do in this situation? And all of this ties into 14th Amendment due process. So now you got the Fourth Amendment, you've got the Eighth Amendment, and you got 14th Amendment due process. Due process means we need to go through a test. We need to create a test that can be used by the courts, both in a criminal situation and in a civil situation, like the civil 1983 civil rights claim, to determine how or whether or not an officer was reasonable in their interactions with someone. So that brings us to the idea of all right, now we've got this test. Thank you, United States Supreme Court, for the test from Graham versus Connor. And so now where do we go through that? In the actual case, in the Graham case, the court outlined a non-exhaustive list of factors to determine when an officer's use of force is objectively reasonable. So you have to look at the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or to others, and whether he is actively resisting arrest or attempting to evade arrest by flight, which just means leaving, not like actually flying, but running away. I used to tell people all the time in Georgia, the resisting and obstructing charge, there's a misdemeanor for running. In Michigan, it's felony. So it's a 2-year felony if you just run away from police officers, if they are in the lawful discharge of their duties and you do something that resists or opposes them. It's a whole lot of different factors that you have to figure out in regards to that. But you have to look at, what's going on as far as the crime, what is the threat to people at the time, and, resisting or attempting to resist arrest. Several different parts of that are important. When we look at what's happening right now, particularly in Minneapolis with ICE and the people who are observers. My first question, and the first question that I think should happen in any determination of what's going on with these cases is, what is the crime? What is the crime that Ms. Good or the gentleman from yesterday whose name is escaping me right now, I apologize. What crime are they committing? Is it a crime to record ICE? Is it a crime to, stand out in the street or to have your car in the street? There are crimes for some of those things. So it could be that we're looking at that crime, that the police officers have reasonable articulable suspicion to say that somebody is committing a crime in those situations. Okay, so if they are committing a crime, then what is the severity of the potential crime at issue? Just recording them or talking to them or yelling at them or cursing at the officers or agents is not a crime. But some of the other actions may be. Then you have to look at whether or not there's an immediate threat to the safety of officers or other people involved. And you have to look at if the person was resisting arrest. And again, that arrest must be a lawful arrest or trying to evade arrest. The arrest needs to be lawful. Remember those questions. Remember what the original lawsuit was in the Graham case. And the things that they were alleging were violations of civil rights. Okay? And so then the general standard, not just from Graham versus Connor, but then all the cases that came after it, were given the facts known at the time, would a similarly trained and experienced officer respond in a similar fashion? That response goes towards the reasonableness of the officer. Okay? So the standard for a reasonable officer is, given the facts known at the time, would a similarly trained and experienced officer, agent, law enforcement, whoever they may be, respond in a similar fashion? And you are to look at a list. That's not the only thing, but some of the things you should look at is there a crime that they're investigating? What is the severity of that crime? What is the threat? So obviously the courts, that third branch of government, are looking at all of this after the fact, right? But they're supposed to be looking at that in the lens of what the officer was doing at the time. So I tell people a lot of the case law that I do now and the trials that I do now are termination of parental rights trials. Sometimes in that case, we're looking at 17 years, 18 years, maybe even more, depending on if we're dealing with something that happened with another child. Sometimes we're looking at things that happened for years in those trials and piecing it all together and determining whether or not it meets the law's requirements to terminate parental rights. A lot of times in these cases, either a criminal charge against a police officer or a civil lawsuit against a police officer for what they did, you're looking at seconds, minutes, a very short time frame. And none of us can say what it means to be on the scene and see it happen. We can watch videos, we can hear testimony. All those things happen in courts. And then it's the court's job to determine the facts and how the law applies, right? The trier of fact. But what you have to do also in determining this reasonable officer standard is put yourself in the role of the officer. Remembering that story that I told at the beginning about adrenaline dumps and other things of that nature, I've never been a police officer. As a prosecutor, I was technically law enforcement, but I've never been a police officer. I don't know what it is like to be a police officer, but I have cross-examined and examined as a prosecutor many police officers and cross-examined them. You have to get to what they were thinking, what their training was, and what was happening. All of that is going to be relevant in any action that comes to the courts. So how does that work? Because a big part of that is officer training. The example that I can give to you is I did a whole lot of DUI defense at the beginning of my career. And my bosses trained me. We were trained by the person who trained the state officers in Georgia who did DUIs, because one of the counties where I worked used to do DUI checkpoints every weekend. They probably still do. And so I used to be able to do a standardized field sobriety investigation probably as well as any police officer on the street, because I did it so often. I trained on it so often. I went to trainings. I did, I was reading cases for so long in regards to it, horizontal gaze, nystagmus, and the one leg stand and the walk and turn. I could do that, analyze it in my sleep. I did it so often. And one of the biggest things that we did if we had a trial on a DUI and there was standardized field sobriety is we would subpoena the book, the training manual. So there were certain officers in that county who were specifically trained to do these investigations, and they'd be ready. They'd be ready to go at us and go back and forth in regards to training. And as a defense attorney, it was my job to make sure, because it's called standardized field sobriety for a reason. There's a whole book, there's a whole training, and you're supposed to do it the same way every time. The reason you're supposed to do it the same way every time is because that's how you get the proper results to determine whether or not somebody is intoxicated based on these tests. They've been tested scientifically and all these other things. So I remember one time I had a case where my client was very tall. He was like 6'7" or 6'8". Oh God, no, 6'7". No, but I really do think that's about the height that he was. My police officer in that case was very tall, but he was maybe only about 6'2" or 6'3". And so when you're doing horizontal gaze nystagmus, which is the test where they do like this and they move and you're supposed to follow the eye. One of the things that the manual says is if there is a significant height difference in between people. So if your officer is 6 foot and, I had another case with a woman who was like 4'11", the officer has to get to the eye level of the person who they're giving horizontal gaze nystagmus to. And that's standardized. That's for a reason. Because if, somebody is 4'11" looking up at somebody 6 foot tall and doing horizontal gaze nystagmus, you may see the nystagmus, which is the shaking of the eye, because of some other strain that is happening to their body because they're looking up at you as opposed to looking straight like the book says. And so sometimes we were getting into these discussions, maybe not during a jury trial, but more so in a motion to suppress the evidence based on the Fourth Amendment, search and seizure. You violated that because you didn't use it standardized. So, I'm trying to get evidence kicked out, which may have been the fact that the nystagmus was seen and that my client was intoxicated. But if you did it wrong, if the process was wrong, then that evidence should not come in. And so we would go through all the different situations and scenarios in regards to what the training was, what your policy manual says, and did you do that? At the time, when you were on the side of the road doing this investigation, did you do that? And sometimes things would come up. I had one case where my client was wearing 6-inch stiletto boots. And so the idea of her taking those shoes off in the middle of the night in the cold, did that affect, if she had worn the boots, would that have affected one leg stand, walk, and turn? With her taking them off and now being barefoot after wearing them, at the club for 5 hours. I mean, this is all of these different fact scenarios are the things that determine whether or not the officer was reasonable. So you have to get down into the nitty gritty. You have to do these investigations. And again, this is if the officer is charged with a crime, but also if they're sued civilly, but also in the defendant's case, if the defendant does get charged with a crime, whether or not the police officer was reasonable during the course of the investigation. Because if they weren't, and there's a violation of the Fourth Amendment or the Eighth Amendment or 14th Amendment due process, then that evidence doesn't come in. And if that evidence doesn't come in, then it can't be used to convict somebody or for them to be civilly found liable in a civil case. So all of this determination, looking at the different factors, determining reasonableness happens over a long period of time. And oftentimes we're looking at seconds or minutes and analyzing whether or not an officer was reasonable during that time. It is a heavy area of litigation in the United States. It happens all the time. And it's what should be happening in all situations, including the situations that are now coming up on the national stage. We need to be looking at whether or not the officer was reasonable and how they are trained. And again, remember that we're also looking at jurisdiction. So we're looking at all of these federal things, Fourth Amendment, Eighth Amendment, 14th Amendment, and reasonable officer standard comes from a United States Supreme Court case. It applies to state officers, city officers, township officers, as well as federal law enforcement. It applies to all of them. So you may be thinking, I want to know more about what that looks like then. Like, how are they trained? I just pulled this screenshot from earlier today to give you an example of how you can find it. And you may have heard people talking about it with the cases in Minneapolis right now. The training for Homeland Security, investigations, Border Patrol, ICE, all of those different agencies, they're all available online. So this is from ice.gov, and you'll see that within the URL here, it says FOIA, that is FOIA, Freedom of Information Act, which is a federal act that says that these type of documents, the things that officers are trained on, are available to the public. That's part of, government being open, is that we're supposed to be able to see how they're trained. So just like I used to subpoena that DUI book, and I would bring that DUI book and tell the officer to bring it when we were questioning them in regards to that in an investigation. Anybody can view the most recent book. I think this is the most recent full edition is 2020, but as you can see, there were updates in 2025 based off of executive orders. And again, Homeland Security, ICE, Border Patrol are all under the executive branch of government, under the president, which is to enforce law. Congress makes law. Executive branch enforces law. Judicial branch interprets law. So all of this is available for you. This is a 58-page document that has updates. And so they're supposed to update it. And if they update it, then it should be available. But these are all things that anybody can go and find and do those interpretations that we talked about in determining reasonableness. I've talked a lot about civil versus criminal, because like I said, you could be looking at the same reasonable officer standard and making the same determination in a criminal case against the police officer, in a civil action against the police officer or the police agency, or in a defendant's case where you're looking at the reasonableness of the police officer and their investigation. So it goes through all three of those factors that we have to look at, right? And so then the other part of that is, if it was determined that an officer is reasonable, then they are going to be immune from prosecution. They're going to be immune from civil liability. That's the next step of it. When I was talking to my class about privileges and immunities, this idea that if you are reasonable under this test from Graham, then you're going to be immune from as long as you were in the lawful discharge of your duty. So the idea of what your duty is important. What is the duty, role, and function of an ICE agent or a Border Patrol officer or agent? And let me explain it to you this way. I am currently a special appointed attorney general for the state of Michigan. I have very specifically taken an oath. I've taken many oaths as a lawyer over the years, but as every year I do an oath as a special appointed attorney general to do child support prosecutions. That's the only thing that I do for the attorney general's office. So very shortly after I started doing that work, I had been practicing for over 15 years at the time. I was in court, and there was another case that the attorney general was handling in the criminal court, also in the same division that I work for the attorney general's office, but a different type of case. And the defense attorney was trying to talk to me about that case. And I said, well, I don't have any information on that case. I'm only here on the child support prosecution case. But let me, talk to administrative assistants and see if I can find any information on it for you. So I emailed the administrative assistants, and they said, oh, okay, we'll get the attorney general who's supposed to deal with it on the line. It was like a status conference. So it's just, what's the current status of the case? And, I've been practicing law for 15 years, been doing criminal defense and prosecution for many years. I said, well, I could handle it, if there's a reason why the prosecutor isn't on Zoom. I was in person. And the administrative assistant very nicely said, well, you can't. You're not allowed to, because that's not part of your oath. You're only supposed to be dealing with child support prosecutions. And I said, oh, yep, you're right. Yeah, I can't do that. Even though I had the knowledge, the ability to be able to handle that case. My oath was to do a specific type of case, is to do a specific type of case. And so I can't do this other type of case. I'm not allowed to. So when you're looking at whether or not somebody is acting in the scope of their duty, whether it's in the scope of their oath, then, you know, if they're going after somebody for getting out in the middle of the road, or doing something else that would be disorderly conduct at the state level, or something of that nature, is that the lawful discharge of their duty as a federal agent? So they may be investigating a crime, but is it a crime for which they have the ability to investigate? I just had another case where I got a letter that said that the officer who was the lead officer on the case was not MCOLES certified at the time that the investigation took place. MCOLES is a certification that the officers have to go through, and they have to be certified in order to be a police officer in the state of Michigan. So that's going to impact every case during the period of time that officer was not MCOLES certified. So even though he was employed by the department and out on the street, he was not certified. And because of that, when you're looking at things like reasonable officer standard, all of the stuff that he is supposed to do in order to get certified, if he's not certified, shows that didn't happen. So that can impact the ability of any of the evidence that he gathered being able to come in. So this is really, it's very technical. And we're all looking at something that, again, may have happened for seconds or minutes, but these tests, what the court tells us we're supposed to do in the judicial branch, this is what we're supposed to be doing. So sometimes there are some counter arguments. And one of the counter arguments that has come up with the Graham versus Connor case is from Lemons versus City of Milwaukee. And this case talks about, they're looking at the Graham case and they're trying to figure out whether or not the Graham case applies to any case that involves somebody being seized. Again, that's Fourth Amendment search and seizure, where the Constitution and the Fourth Amendment then apply. And that court says that the broad statement that the Graham court, the Rehnquist court, the United States Supreme Court, says it applies to any seizure of a free citizen, that's in dicta. So dicta means it's not in the full opinion of the case, it's in like a footnote or, spoken about in passing. Graham involved claims of excessive force during an investigatory stop. So remember, that officer was trying to figure out, did he steal something from the store? Why is he acting so funny when he was in his diabetic episodes? So he was trying to figure out if he was on drugs, disorderly, stealing, any of those different things. So he pulled him over as an investigatory stop. He had reasonable articulable suspicion to say that a crime may have been taking place. In other portions of the opinion, the court confined its discussion to investigatory stops and arrests, leaving open the possibility that some instances of force used on citizens may fall outside of Graham's holding. So the court, and this is a district court, a federal district court, and then also I think the circuit court looked at this and never made it up to the United States Supreme Court. But their determination is that maybe Graham does not apply all the time. So we might not have to look at the reasonable officer standard all the time. Because if somebody is encountering police and it is not investigatory stop or arrest, then maybe Graham doesn't apply. And there's a couple of other cases that have distinguished this and talked about this, both at the state level and also at the federal level. So again, the question goes back to, and I'm going to go back real quickly, hopefully, to our standard. So the list of factors that we need to look at: severity of the crime at issue, threat to people in the public, attempting to evade arrest or flight. What would a similarly trained officer do at that time? Who is the officer? What is their role? Is this something they're supposed to be doing? Are you supposed to be investigating people in traffic? Are you supposed to be investigating people who are yelling at you and recording you? Is that a crime, either federally or in the state or jurisdiction in which you are? All of those are important considerations of determining whether or not the reasonable officer standard is going to be applied in the case, or whether or not we're looking at Fourth Amendment, Eighth Amendment, cruel and unusual punishment, and 14th Amendment due process. So it's a lot of different factors. And we can get evidence such as pulling via FOIA requests or different training manuals, different things of that nature. We can look at that. There can be a civil case. There can be a criminal case. There's supposed to be investigations going on right now. Those investigations should take place. Because we saw the videos, we've seen, again, the government put out things in the past week involving other cases where things have been doctored. So the full investigations need to be able to take place by any agency of the government who jurisdiction falls under for them to be able to investigate those things. And these are the standards that the law says they're supposed to be looking at. These are the standards. You don't get to any discussion of immunity until you determine whether or not the officer or agent was reasonable, or if the reasonableness standard should apply. So if you're vice president of the United States who went to a Ivy League law school is saying that immunity applies to somebody without doing any of these tests, that is wrong. Plain and simple. And somebody who's been trained on it should know better than to get up and say that somebody is immune from prosecution or that an investigation shouldn't happen. Because the law and the precedent make it very clear that there are layers of things that you should be looking at to determine what standards are to apply before you even get into any discussion about immunity. Should the reasonable officer standard apply from the Graham case? Then, if it does apply, you look at all those different factors. You look at the training and you determine whether or not each of the individual officers' actions were reasonable at the time. And is the agency's policy reasonable? All of those things have to be looked at. Nobody can do that in 20 minutes, 2 hours, or 24 hours. So all the conclusion statements make absolutely no sense. These cases take years. One of the cases that cites and has a discussion of the Graham case is the Derek Chauvin case. Derek Chauvin is the officer who put his knee on George Floyd's neck. And the Graham case was considered and discussed both in his criminal trial and in the civil trial against him for a violation of George Floyd's civil rights, and in the determination of whether or not George Floyd had committed a crime, what evidence would have been even introduced against him for what they said was passing a counterfeit bill at the store. Was the reaction of that reasonable? All of that had to happen in investigation. Nobody who is trained and knows what this is supposed to be or wants to quote it should be making any kind of conclusion about that the same day or 24 hours or 48 hours later. That's irresponsible of anybody who knows the law. And with the FOIA, all of you can access it. And now any of you who haven't gone to law school or taken my constitutional law class in undergrad can go back and review this. And I think if you do, you would say, okay, well, we can't make any determinations yet, because there's a whole lot of the law that needs to be done, and people need to pull this information in order to make those decisions. And the people who were trying to make those decisions in some of the cases that have made national headlines and news lately have been told no, to not do your job. This is their job. Looking at the Graham case, determining the reasonable officer standard to determine whether or not somebody should or should not have immunity is their job, and they're being told that they're not able to do that. And some people have resigned because of being told that. So this is this is what the third branch of government is supposed to be doing. And I understand that some people are in the executive branch of government and they're in charge of enforcing the law. and they're making statements. But some of those people making those statements have been trained on what happens in the third branch, in the judicial branch. They know better. And so they need to stop saying things that they know are not true, because that's not the process. The process is what I just gave to you. So I'm really hoping that we get back to a point in the third branch of government, in the judicial branch, where we follow precedent, where we follow the law, where we do the things that the Graham Court, a court that was very divided in regards to their judicial ideology, were 9-0. Unanimous decision that a reasonable officer standard should apply, and that you have to make that determination before you have any discussion about immunity. That directed verdict was because they determined that there was immunity for the officers in that situation. And a 9-0 court, the Rehnquist court, not too long ago, many of us were alive when this happened. They laid it out for what it should be. Hasn't been overturned. And all the different factors that you should be looking at, they're in case law. So we need to be doing this process the proper way, because all of us, the police officers, deserve it to be done the proper way. Police agencies and, leagues and all the, people who support police, they champion the Graham decision. It was easier for them if they had with maliciousness as the, and being sadistic. There's very few people who fall under that category. But they were fine with this test because it gave them the ability to show their training and experience, and to show that they were properly training their officers. But if you're not, and you have officers doing things that fall without the realm of which they have been trained, that's when you end up with situations like this. And that has been the case over decades and centuries in the United States. That's why this case law exists. People are charged with resisting and obstructing officers every day. People are harmed by officers every day. Officers are harmed by civilians every day. It's not an easy job. They're not easy situations. That's why the framework exists. That's why it's one of the most heavily litigated parts of our law. 4th Amendment, 8th Amendment, 14th Amendment. So making conclusions this early on makes no sense, and it hurts everybody. It hurts the police officers. It hurts the police departments. It hurts the local folks. It hurts the federal folks. It hurts citizens. It hurts non-citizens. It hurts all of us who are encountering this on a day-to-day basis. So my plea is that all these folks who know what they're supposed to be doing in the different roles, do it. Make the proper determinations so that we don't have anything else happen to anybody, officer or civilian. I don't think I have any questions, but I will check. I've been going in. I don't see any questions. I got to check all my little streams. Again, this will be available on Facebook for about 30 days, I think, before they get rid of it, but it will always be available on my law office YouTube page. And if you have the opportunity and you want to ask questions after I finish this live broadcast and you haven't been able to ask it here, share it, have discussions. I think that's important. I plan to be back with you all the last Friday in February for my next session. I haven't picked the topic yet. I'm going to think about picking topics because, like I said, I picked this topic before everything happened yesterday, but I wanted to continue with it because I think the discussion is important and we need to be having the discussion. So I'm going to end the stream for today. But again, you can find the video on at ELM Law Office on YouTube, or the Law Office of Elizabeth L. McCree on Facebook. And I think I've always also shared it to my personal page for people who are on my personal page. But I hope that this promotes a conversation that really discusses, what the actual standards are, and in going by those actual standards, that we do the work right so that everybody can be protected, and that this stops. We're not going to stop people getting arrested for resisting and obstructing. We should adjust the way that we do it. But, especially the level of violence that is taking place right now, we do absolutely need to stop that. Thank you, Jeanette. I see your responses. All right, so I'm going to end the stream for today. Everybody stay safe and warm out there, and that applies apparently to everybody in the whole country today. And if anybody's watching internationally, I know there's one person who watches internationally. Everybody stay safe and warm out there, and I hope to see you next month. Thank you.